Okay, you're now live.
Is everybody ready to get started?
Yes.
Yes.
Then we will call this meeting of the Civil Service Board to order. And Ms. Long, do we have a quorum?
Yes, ma'am.
Okay. Has everybody had a chance to look at the proposed agenda?
Yes.
Yes.
Okay. Are there any additions, changes, questions?
No.
Hearing none, I'll entertain a motion to move the agenda as presented.
I so move that the agenda be approved as presented.
Is there a second?
Second.
Mike Hahn, I second.
It's been moved and seconded. We proceed with the agenda as printed. All in favor, let it be known by saying aye.
Madam Chair, please remember, as a remote meeting, you do have to continue through with a roll call vote.
Roll call.
Oh, I'm sorry. Okay. All right. Mr. Devereaux,
Aye.
are you present? We're going to come back to but just a roll call of who's present. Mr. Devereaux,
Present.
Mr. Eskovitz,
Present.
Mr. Hahn,
Present.
Mr. Webb,
Present.
and then I'm present. So everybody's here, and so we'll go back to been moved and properly seconded to accept the agenda as presented. All in favor, please let it be known by saying aye.
Aye.
We have to roll call.
You do. You have to roll call.
Oh, I'm sorry. Well, let's just go back to that again. Mr. Devereaux, are you in favor of proceeding with the agenda as presented?
Aye.
Mr. Devereaux, I said Mr. Devereaux, Mr. Eskovitz,
Aye.
Mr. Hahn,
Aye.
Mr. Webb,
Aye.
and I do too. So that's unanimous. Okay, we have approved the agenda. Now, the approval of the minutes from September. Has everybody had a chance to receive and review those?
Yes.
I'll entertain a motion to approve the minutes as they have been presented from the September 3rd, 2020 meeting.
I so move that the minutes, Alan Eskovitz. I so move that the minutes from September 3rd meeting be approved.
Is there a second?
Mike Hahn, I second.
It's been moved and seconded. We'll vote in favor of adopting the minutes as they have been sent out. Mr. Devereaux?
Aye.
Mr. Eskovitz?
Aye.
Mr. Hahn?
Aye.
Mr. Webb?
Aye.
And I vote yes as well. Are there any updates or reports?
Madam Chair, I would like to share one piece of information for the board. Just to let you all know that Peggy Rowe has fully stepped into her role as special assistant to the city manager, special assistant, yes, to the city manager. And in doing that, the city manager has asked me to fill in as interim HR director. Okay. So I am now serving in that role.
Well, congratulations.
Thank you.
Okay. Any other updates or reports? Okay. We'll continue with unfinished business. Discussion of the substantive rules. Did everybody receive the copy of the rules? It was a 3-page document.
Yes.
Yes.
And is Mr. Maddox on the call? Did you want to say anything, Mr. Maddox?
Yes, Madam Chairperson, I am here, and hello to everybody. Good to see you all. I apologize. There's an airplane flying over my head right as I took it off mute, so that's I apologize. So you did get the rules. You got them just a few days ago. I'm still ironing out last details. Not asking here. And you're welcome to. It's your board. Y'all do what you like. But not asking y'all to vote on these today. What I wanted to do is get this draft in front of you. have a chance to answer any questions, talk with y'all a little bit about a couple of the provisions that are in here. And hopefully next month, your December meeting, take a vote on these rules. This part of this is I'm still working out some details with some of the unions, the employee associations. And I'm afraid that actually Rick Tullis, who is the president of he's been very, very ill for at least a week now. And everybody keep him in your thoughts and prayers. He's I think, been in the hospital, and I've been unable to speak with him for about a week and a half. So that's certainly thrown a little bit of a touch base with us. I've worked with the PBA primarily over the last few months, but with touch base with the FOP, we've made some changes to the rules in line with their recommendations. We're at odds over provisions, but we're getting, but I think there's a compromise that can be struck. And I think in the end, it might be one of those times we say, here, the FOP or these other groups are here, board, what do you rule? And then maybe we ultimately leave it to the city council. There's at least one of those provisions. I've also spoken with the Firefighters Association. I only had a chance to sit down with Mullins last week, though, and he asked so that he would need some more time to look over the rule. And I think we have a whole another month. There's no reason not to keep talking, try to figure out those things. There was just in his quick look at it, I don't want to speak for him. It seemed like we had a few things we needed to talk over, but for the most part, it was a very productive, positive meeting. I'm hopeful there.
Okay.
So I assume look over the rule. Some things have changed since the last time we spoke about this. There's really 2-3 big changes. The biggest change that has come about as part of this, you'll remember that we talked about what is the definition of justified. That's one of the main goals for this is, when does it mean that an employment decision by the city is justified? Well, this rule seeks to do, it kind of breaks justified into 2 parts. Justified means that the employee received due process, which is another definition under this rule, and that the decision that the policy violation, whether a policy violation occurred, is then judged by according to abuse of discretion standard. The first big change has to do with that due process bit. You'll see in the number 4 definition, due process, it says that due process is that you receive notice of your allegations, of the allegations against the employee, and that they receive an opportunity to be heard by a department director prior to the decision being made to discharge, take whatever the complaint of employment action is. What we've added in there, if a department by departmental policy utilizes a discipline matrix, which is a policy whereby if the employee committed this policy violation, then the punishment is this. They committed this policy violation, the punishment is that. Up to and punishable by termination. Some things are. It gives a lot of. It takes away a lot of the uncertainty out of the disciplinary process. But under this rule, if a department by policy utilize the disciplinary matrix, then their due process will include discipline in line with that matrix. That's sort of the first change that's come about since the last time we talked about this. And that's based on, feedback from the different employment groups. The other big change is the board said we talked about what abuse of discretion means in this text, and y'all suggested that there needs to be that term needs to be better defined. What does abuse of discretion mean? So I went to my shelf, pulled up my Black's-Law dictionary, and so now this includes a abuse of discretion shall mean a decision that is grossly unsound, patently unreasonable, or wholly unsupported by substantial evidence. That means that if a police chief makes a decision to terminate somebody or suspend somebody or demote somebody, and the decision is grossly unsound, wholly unreasonable, or wholly unsupported by substantial evidence, then that would not be justified. However, the decision is not grossly unsound. It is not patently unreasonable, or it is not wholly unsupported by substantial evidence. Then the decision that a policy violation occurred by this, if you're following this rule.
John, can I ask a quick question, not to interrupt?
Absolutely.
And this is the lawyer in me asking questions.
Mm-hmm.
I understand, and I figured that this definition was out of Black's Law Dictionary. So the decision of when a matter would come in front of the board, it would be our determination of whether it was grossly unsound or not. Would that be correct?
Well, your decision is ultimately, and Mr. Henning, please jump in if I speak out of school. But your decision is all justified, and this is sort of a subset of what is justified.
Okay.
You have to have a arbitration, and you have to have due process, right?
Mm-hmm.
In determining whether a policy violation occurred, that decision is according to an abuse of discretion. So, if the board thinks that the decision that a policy violation occurred was, let me get the language exactly right, was grossly unsound or wholly unsupported by substantial evidence, then the board would say that, well, that was not justified. That decision was not justified.
Okay.
Are there any other questions about that stand before I move on?
Yeah, John, Rick Devereaux got a question on it. So in paragraph 2, when it's about an employment action is per se justified upon a showing that an employee violated any law, etc., is the discretion standard in paragraph 4 applied to that paragraph as well, or are those independent? In other words, if a supervisor says you broke such and such city or departmental policy, I'm discharging you because of that, does it also need that there has to be the paragraph 4, it also has to not be an abuse of discretion? Well, or are those independent?
They're not exactly independent. It all works together. So think about, okay, I want to say that something is justified, right? So if I'm a department director trying to say that a decision is just, I have to first make sure the employee due process, right? That they had notice of the allegations, that they've had an opportunity to be heard before the decision is made, and if my department utilizes a disciplinary, that the discipline that I'm handling down line with that disciplinary matrix. So if, for instance, it's a police officer who engaged in excessive force, well, termination might be justified. If it's a police officer who showed up late one day and then was fired for it, well, that would not be a disciplinary process, disciplinary matrix, and therefore he did not receive due process. Does that make sense? That's one component, due process. The other component of it is okay, a policy violation actually occurred. That this person's conduct was violated departmental policy. And that part of it is according to an abuse of discretion standard. That is where the decision that the department, that the officer or the employee violated a rule of conduct has to be supported by substantial evidence. It has to be not grossly unsound, or patently unreasonable. Do you see how that works together? So
So if I can make sure I understand by an example, let's say it's a department that does not have a matrix, okay? And let's say the person was fired because they got a speeding ticket, that they went 10 miles over the limit somewhere. Their boss said, you broke the law, I'm gonna fire you. But we all say that's pretty, maybe it's a 20-year employee. That's the only thing. It seems kind of arbitrary. In that case, that would be an abuse of discretion, correct? Since it would be patently unreasonable to fire a 20-year city employee simply because they got a speeding ticket for going 10 miles over the limit. Is that fair?
I do think that would fall under patently unreasonable, by your definition there. However, I do want to say that the intent of, if somebody is cutting in, if everybody could check that they're muted real quick, so I'm catching some weird sounds. The goal of this is to put some objectivity to this and also to put some of the discretion in the hands of these department directors who are running their departments and who we do at a point need to know more about their respective departments than a lot of us do. Know more about policing, know more about sanitation, and know about the inner workings of their departments. So when it comes to decisions about whether a certain level of punishment is fair, we are trying to place more. I want to be completely upfront about this. We're trying to place more of that discretion in the hands of directors. So I don't want y'all to feel like I'm hiding a ball or anything with any of this. Are there any other questions around this?
John, I had a couple of others. Under B1 classified service, would
Yes.
it be preferable, and again, at the risk of sounding nitpicky, to say Civil Service Act instead of Civil Service Law?
I can even go more precise than that, Kara. I could do the Civil Service Act of 1959 as I've got that in somewhere, so I can make that more precise. It's a good idea.
I don't know that you need to go that far with it, John. I think the point is you have referenced it as the actual Civil Service Act in the first paragraph in A. I think is that then when you get down to B2 and you say the Civil Service Law, I think you've already done it. You could just say Act there.
Yeah.
Sure. Okay. Yeah. I love. Please point out stuff like that because sometimes I've read it till my eyes cross.
I understand. And one other, under, what is it? B3-6. At the end of the second line, it says of a city policy or poor work performance. I might just suggest unsatisfactory as a better word, but I mean,
you're looking at
under suspension.
Involuntary.
Second.
Unsatisfactory. Sure, we can. Yeah, that's more precise.
Yeah, and I did have another question, and this is just a question. In that same paragraph, involuntary or temporary unpaid leave of more than 10 consecutive shifts. How did you get at 10? And the reason I'm asking is because depending on how they work, because like I think some firefighters work like 2 days on, 2 days off. So to get to 10 consecutive shifts, you might be 2-3 weeks, which is a pretty long period of time. Is there any reason? How did the number 10 come up? I mean, is it just a round number, or is there some specific reason for that?
The reason for that is it comes from the Civil Service Board's old rules that they had back in the day. That's long been part of the city's policies, and it was an old Civil Service Board rule.
Okay.
Prior to rules being appealed back in the day.
Okay. I was just wondering where that specific number came from. Mm-hmm. Could it be changed? Can we put?
Certainly.
Okay.
If that's something y'all are interested in, or you think it'd be better clarified, certainly.
Madam Chair, we could consider maybe trying to. I mean, 10 consecutive shifts might be okay for some positions, but not others, and maybe you have an hour limit of a number of weeks or something.
Yeah.
Not to exceed X weeks. Maybe.
Yeah.
Yeah. And I have to say, firefighter pay and the way that they are compensated is sometimes so very, it's complicated. I have to have, usually I call Scott to tell me, please explain this to me. I just don't understand. So it could be that there's some parity between a firefighter shift versus another employee, but I don't know that well enough. That's something I can certainly try to around.
Okay.
Carol.
And
Hello?
Alan, did you have a question?
Yes, I had a couple questions, but before I want to talk about one procedural thing. For the December meeting, John, you mentioned that there's some differences in the associations or unions that still need to be ironed out. If they're not, we had talked about having members of those organizations present at the next meeting, perhaps, so we could hear their thoughts too, if there are differences between the document and what their thinking is. So can we, and Sergeant Tullis may need to have a representative of PBA if he's still ill. But I would like to have that in place for the December meeting. But I want to talk about, John, you mentioned 10 was from the old Civil Service Act. Are you referencing the 2009 Act or the original when you said 10?
It's actually not from the Act. It's from the old Civil Service Board's rules.
Rules, okay.
Yeah, previously promulgated rules that are, I mean, there's been there's been substantive rules in the past that the Civil Service Board had. They were all repealed though.
Okay.
13, I think. And since this is just really going back to that, I don't think the city has a real strong opinion about this. I think we do want to give department directors an ability to issue suspensions for minor, well, I want to say, but for that falls short of having to have a full-blown hearing about it.
Yeah.
I think that everybody agrees that's not a great use of resources to call this whole board together when somebody receives a one-day suspension for something.
Okay, understood.
Okay.
Under,
I'll interrupt this one point.
Okay.
John, might those suspensions also be worked into a disciplinary matrix so that you would know departmentally if they have a matrix when you hit a suspension being possible, and it would be less than a grievable suspension, it would be part of your disciplinary matrix.
That would be correct.
Okay. Under grievance hearing standards, point 3, or I'm sorry, 2, when you talk about employee violated any law, could we be more specific and say a law related to their employment? Because, for example, if someone who's not responsible for being in a vehicle, a non-police officer, could be somebody not from the sanitation, but someone who doesn't require driving as part of their job, and they get a speeding ticket, one could argue that, well, they violated a law, and they could be there could be some punishment for that violation. So could we just say related to their employment or some language similar to that?
I think we can maybe try to
more specific.
I would just top of my head say it's got to be related to their employment. I'm a little bit concerned because I mean there's some fairly serious things that might not be related to somebody's job as a sanitation worker, but that might nevertheless exclude them from being able to continue city service.
Okay.
I understand your intent. You want to be able to keep out some minor traffic offenses, things like that.
Right.
But I don't want because I've been henpecked about these kinds of rules before. I'm a little bit worried about creating giant exceptions like that potentially giant exceptions.
I'm just concerned about a minor violation outside of work performance that could be used as some reason to file or make charges against somebody related to their employment. But think about that and as we go forward. I have a question on probationary employees. And my understanding is that candidates who are, I should say cadets who are going through the police academy, and I'm not sure how they're referred to, but individuals going through the fire academy, they start getting paid as soon as they enter the academy and start going through the training. So if you count that as employment, for example, a police officer will go beyond the 6 months of training. They have another 3 months of field training. And so it could go well beyond the 365 days, could it not?
Well, I'm very glad you're bringing this up, because this was actually the next place I was going to go to. The other thing that has changed since the last time we talked about it, and this is where I have some disagreement with, not vociferous, but we're still trying to work out this section with employment unions. And you're exactly correct. The reason for some of these changes in here are that the way the city treats the way treats cadets in the fire academy and the police department. They start getting paid, and they're city employees from the first day. That contributes to a problem, though, in that if we have a probationary period that's only 6 months, well, about the time they're getting out of the police academy and before they've served a single day as a patrol officer, they all of a sudden have civil service board rights. We don't have any time to evaluate them prior to them enjoying full rights of appeal and all the expenses that go along with that. It's also true that they're in field training for a good bit of time after they're out of BLET. So the idea with this, and this is why the way the city is currently proposing this, is that they begin probationary employees. However, the probationary period expires a year after their graduation from the fire academy or BLET. So that will get them through their field training and give some time for the city to evaluate them when they're on their own serving as employees. And now I'll say that this is the FOP has not wanted to make a change like this. The PBA has been in favor of this and has been okay with this. When I spoke with Mr. Mullins last week, he indicated that he felt like the rule, it might be slightly different for firefighters because they don't have a intensive field training like police do. So, but I know that the police unions do feel like there should be parity with the firefighter association. So they don't want rules for firefighters, rules for police that are significantly different from each other. I think ultimately this is going to be a place of compromise. City saying, how about a year after field training or after graduation academy and BLET? They're thinking a shorter amount of time, and where we land on that might ultimately be like, here's where we are. City council, what do you think? So that's a very long-winded way of answering your question, I hope.
John, my guess is the board members generally can understand what the intent of that rule, and I think it makes perfect sense to everybody that if you're going to make a probationary period, it really ought to apply from the time the person's fully, permitted, maybe even legally permitted to do that job and get 1 solid year from that point. So I can see that. I don't know quite how you get around what's in the civil service law about it says except, no, I think it means no, it says not. Probationary period or any extension thereof may exceed 1 year in the aggregate. I'm afraid you'd be set up for somebody to argue who falls into that time period, whatever the length is, between, they're a paid person who works for the city and does their work through the academy or BLET. They're going to try to argue that's when my year started, and that's by statute. But I think we agree with the intent.
Yeah, and it's something I've anticipated in that we have to work out through the HR process, where they do not actually become full city employees or probationary employees until they have graduated from the academy. There might be a way to work it with their, and there might be a contractual way to work this. John, I'd be interested in hearing your thoughts on it, because I do think there's a way to do it, but we will have to address that challenge in the act.
Is there a way? I'll ask both Attorney Johns. is there a way to put some language to that effect into this to say a definition of an employee of the actual fire and police departments is, or the date starts from the date you're fully, cleared to do the job or free, or does not count, your training time does not count towards your probation period or something. I'm just mangled that terribly, but is there a way to put something like that in this rule?
There may be a way to skin this cat. I'm a little want to have folks who are kind of city employees, but kind of not. It's not fair to them. I feel like, and it might present some other employment law challenges that are separate and apart from what we're trying to accomplish with the Civil Service Act. But
yeah, and I'm sorry to interrupt, John. I feel like that could accomplish the purpose of the Civil Service Act. If I were the city's attorney, and John, you tell me if I'm wrong, but I'd be a little worried about now I'm maybe creating a quasi contractual kind of situation with each of those individuals, and you end up having to fight that out. And then that's potentially even worse, because at least when it's all channeled through the Civil Service Act, it's coming up through this board and then on to court from there. But it's be kind of a wild card potentially. But so it's a bit of a sticky wicket.
it is, and that's why I acknowledge there's still some things to be worked out. I'm hoping to have that ironed out before the but you're exactly correct, and I do think there might be a contractual way to skin this horse, but we'll see.
Okay. I did have one other suggestion.
Yes.
On the third page, it's under the grievance and standards hearings, start on page 2, number 5. The burden of proving the board has jurisdiction over an appeal. Would, instead of an appeal, could I suggest the complaint of action?
Sure.
Because that's really what the board has jurisdiction over, not the appeal, but we're trying to decide if the alleged action, justified whatever happened.
Sure.
I've actually got some proposed language that I'd like to share with John to make a definition of appeal. I don't think this is a huge deal, but I do think we all use the word appeal sort of loosely about what comes before this board. I think adding a definition in here that just says we mean the complaint of act the complaint of employment action that the act discusses will take care of that.
Okay, that's fine.
That's a good idea.
Does anyone else have any questions, comments, observations, thoughts?
I've got one more for paragraph 4 under grievance hearing standards. On the abuse of discretion shall mean a decision that is grossly unsound, patently unreasonable, or wholly unsupported by substantial evidence. As I read that, we as a board could be faced with trying to determine if a supervisor exceeded their discretion. And by reading that, if we determine that a supervisor's action was merely unsound, merely unreasonable, and merely unsupported by the substantial evidence, we would have to rule that the supervisor acted within their discretion because it wasn't grossly unsound, wasn't patently unreasonable, and wasn't wholly unsupported by substantial evidence. That seems like a definition of abuse of discretion that almost would require a supervisor to be acting irrationally. It just seems like a standard that almost takes away any sort of judgment by the Civil Service Board as to whether a decision is within bounds or not. Is there any way we could remove those grossly, patently, and wholly, because they just seem to be almost in a way, unreasonable adjectives to put in there. You know, it kind of reduces us to just judging whether someone's operating as a human being or not, you know?
Well, I will say that the adjectives, patently, these do appear in law pretty regular, and they're applied by judges. And in the administrative law realm, these are certainly very well-known terms. And the idea, when you say, is the person, it has to do with how the person is using their discretion and acknowledging that they have a good bit of discretion. And it's only when they abuse that discretion, and abusive is another one of those kinds of adjectives that, you know, is very strong. And I think you support the idea that it's not just they might have made a decision that I might not have made. It's that they have this power. Are they abusing that authority? Are they abusing that? And that's grossly, patently. I would think those adjectives actually add a lot to this and make it clear what we are seeking, what the standard is.
I get that, but you take my point, right? That if we just merely decide that an action is unsound, unreasonable, and unsupported by substantial evidence, that does not meet the abuse standard. Those adjectives are required.
I can get there with wholly, because I do think if something is only, I do think if something is not supported by substantial evidence, in large part, I could say no, but I do think that patently unreasonable, because it's got to be just clearly unreasonable, not just, well, maybe, but clearly unreasonable, or gross negligence is a whole other thing. There's negligence, which people are routinely immune from. Police officers are routinely immune from negligence. It's then you get to gross negligence. No, that's a different matter. So I could maybe see getting there with the idea of wholly with regard to substantial evidence, but not with grossly and patently.
And I hear you, because you want to favor maximize the discretion of the supervisor. I get that, even to allow supervisors to act unreasonably, which as a board, I feel a little uncomfortable with, that we would have our hands tied, that somebody would be a reasonable person would go, that's an unreasonable decision, or that's an unsound decision. Yet we would have to say, well, it's not grossly unsound. I mean, I get where you're coming from. You're representing the city, but trying to balance this, be fair to an employee that maybe is facing an action. I don't know. That one just seems a little bit, I don't know if I'm comfortable with that.
Well, I think, John, didn't you say that is the definition that you pulled out of the Black's Law Dictionary?
It is.
Carol?
Yeah. Alan?
Just following up on Rick's comment, can we talk about arbitrary versus grossly unsound, or add word arbitrary to this definition of abuse of discretion? Rick, would that get to where your thoughts are?
I guess I don't want to overstate my objection.
No, but I have a question about it's. I have the same question. So an arbitrary action.
Yeah, not being a lawyer and not really understanding how legal language works and it's interpreted. I mean, I think if the rest of the board is sort of comfortable that maybe what we're really talking about here in terms of abuse of discretion really means when someone goes outside the bounds, you know, of sort of what we would all consider legitimate, you know, kind of action, then, you know, then I'm fine with it. It might be just me not understanding the sort of the legal kind of standard.
Could we pass that on to our outside counsel to think about that too?
And I will share that I have given a good bit of thought to the abuse of discretion standard. I've got some thoughts I want to share with the board about it after you've had some more time to digest it. But certainly in time for us to have hopefully as agreed upon set of standards here as we can have. I understand your concern, Rick, and I have given that some thought too. I can tell you based on the case law that the Civil Service Act has these appeals. They move on, as we've all talked about many times. They're de novo appeal to Superior Court, and then meaning that the courts start over from scratch and they reapply this act according to how the finder of fact, the judge or jury, finds it to be. And there have been cases in which I think about the Alley case is one in which the trial court said, and the word they used was this wasn't severe enough of a policy violation to merit dismissal. When we don't really know in that case there's nothing more in the order that was appealed that says, well, why was it too severe or not severe enough, or what the court have in mind exactly. That goes up to the Court of Appeals, and they say merely we're not de novo appeal to the Court of Appeals. We don't decide whether the trial court had that right or not. I say all that to say I do think that abuse of discretion before this board puts a good bit more discretion in the hands of the supervisor than the court applied in several cases. Like we just said, this is not sufficiently severe. But having said, and I think that the courts will continue to apply the precedent that's before the court. It's not going to be what this rule says that decides how it gets decided in a later appeal to the Superior Court. I'm not uncomfortable with abuse of discretion in the sense of I do think some discretion for some can do consideration for what a supervisor reasonably believed and viewed a policy or legal violation at the time was, where this board doesn't substitute its own judgment and says, if I was the supervisor, I wouldn't have found that way. I think that that's in the spirit of the act to say justification of the act. It's not redo the act yourself, that in that sense. I think, and I've got some suggestions I also want to share with John about maybe how to get there in a way that will also make it put some more bounds around what's patently unreasonable, what's wholly unsupported, what's grossly unsound, that the board, I think, will be more comfortable with.
That sounds good. I think we're on the same wavelength.
Does anyone else have any questions, comments, thoughts?
I do. One more, Carol.
Yeah.
Under discharge, John, you mentioned constructive termination in the last sentence there. Are we talking about when a position is eliminated, the employee resigns then, or forced to resign, or tolerable conditions that the employee has no option other than to leave? Can you define that?
Sure. Constructive termination. This is where the employee says that I had to leave because the working conditions were just so bad that I just couldn't stay here anymore. And I don't think that this board is set up to hear that, because there you're talking about a very nebulous sort of employment decision, rather than when you discharge somebody and you give somebody due process. I think this board is well set up to make those kinds of determinations when it is a decision of the city to terminate somebody. But all of a sudden you start getting into constructive termination, you're dealing with really kind of more nebulous harassment and grievance kinds of things that are better handled through other rights that an employee might have, rather than through this board's process. So this is to bring real clarity to what it means when somebody is terminated. It's not that I felt like I needed to quit. It's that, no, we decided that you were terminated. So now that decision is going to be before the board.
And board members, I don't have any disagreement with that at all. I think in fact this board has found it wasn't in a dismissal context, but it was in a different context of employee sort of alleging, hinting at some sort of discriminatory action being the basis of motivation. And I think you all wisely said that doesn't come before this board. We are not a finder of fact about whether some discrimination has taken place. None of that appears in the act. It's not our purview. The only place that I differ with it, and again have some suggested language, is years ago, before a couple of you were members of the board, the board had an employee who alleged an involuntary resignation, and I do think that there are circumstances in which, and I think this was somewhat vetted by it having gone to an appeal to Superior Court, where the Superior Court, at least by implication, said this matter is still before the Civil Service Board. It had found jurisdiction where there was an allegation that I was told I had to resign or be fired. The board found that's the same thing as the dismissal. Now, that doesn't mean that that's automatically justified. It just means that the city then has its burden to prove before you that it is justified. I think that kind of involuntary dismissal, as long as involuntary resignation, as long as we're clear that's not the kind of constructive dismissal we're talking about, I think is within the jurisdiction of the board. And the other ones that John just mentioned clearly are not and should be taken out.
Well, actually, John, I'm going to go ahead and I'm afraid to disagree with you. I do think that type of action should not be something that falls under Civil Service Board jurisdiction. And I'll give you a good reason why I think that is the case. When an employee makes the decision to resign rather than be terminated, this is something that comes up a good bit. And there is calculus that employee has to do. If you resign, then your personnel records remain sealed. You have to say that you resigned. You don't say that you don't go anywhere and say that you can go someplace and say that I resigned my employment. I was not fired. You are not lying. The termination letter that the city would become a public record if you were terminated is not a public record, and you do not have that following you. So by resigning, they gain something from that, right? But if they are terminated, they have their Civil Service Board rights. So it is a decision for the employee to make, and by resigning and then bringing an appeal before the Civil Service Board, it's having your cake and you're eating it and trying to eat it too. And so I do think that there are good reasons why a constructive, all of a sudden you're having to make these kinds of evaluations that I'm not sure a board's real set up to make regarding whether or not it was a constructive termination or a termination. When it's a termination, it shouldn't be something we have to argue about. That's the hope of these rules, is to make something very clear that what a termination is. And if we leave open a door for these constructive terminations, it's not clear, and it's not accomplishing its goal.
I'm just going in real quick. I'm having a hard time hearing John Maddox, but I just want to make sure I understand what you're saying. You're saying that if an employee resigns, then this is saying the discharge is saying that they can't appeal anything to the Civil Service Board. Is that
That's correct?
Okay.
And John, similarly, some of you were breaking up through some of that. I think this merits a longer discussion between us, but I'm not quite sure how something not being a public record is to the reasons that the city had already that were going to justify a dismissal if the person didn't resign. I don't know why that so horribly disadvantages the city. I think that there could be circumstances in which maybe it's spelled out enough to an employee that, what you bring. I want to give it some more thought, but I cannot see a rule that absolutely takes off of the Civil Service Board's plate and a matter where somebody's literally told, it's a gun to the head, you have to resign. I don't know why it's too high a burden to say the city should have justification for that. And again, this has been somewhat vetted with a case in which the board found that it had jurisdiction, and that was more or less by implication anyway, vindicated in Superior Court.
I'm glad to talk about it with you more, John. I do feel pretty strongly, though, that the purpose of these rules is to create some real certainty around these specific topics. And there's a reason why this is because of that case, so that we have some real, some very real guardrails around these things for our decision making. And part of that is it's not so much that an employee it benefits them in some ways, the civil service board rights, but they gain these other things, right? That you agree with that. But if the employee decides that they want to resign, but then the city also has to fight with deal with a civil service board appeal, well, then we are it takes away some of the negotiating room that the city has. I'm open to discussions on it, but I do feel pretty strong. And it might be a place if we disagree on it, we just leave it to council ultimately.
Okay.
Anybody else have any questions, comments, thoughts, observations?
Carol,
Yes.
I have just one, and it's going back to the abuse of discretion. Not to hurt anybody's feelings, but the three adjectives that are used obviously make it relatively more difficult for any decision to be reached. I have no problem with unsound, unreasonable, and unsupported by substantial evidence, but it just seems that you're arbitrarily making it more difficult for the board to have any input into what actually happened. I mean, there again, it seems to be purely to make it easier. I mean, you're going to have to show a whole lot higher, something above unreasonable when you call it patently unreasonable. In the same way with wholly unsound and wholly unsupported by the evidence. There again, I have no problem with the three concepts, just the fact that it seems like we're arbitrarily making it more difficult to even hear something that's based on the unsound, unreasonable, or unsupported by the evidence.
I agree with you that it does create a higher standard with regard to the decision. That is the idea. That's why it's abuse of discretion. It's not just that ends within their discretion, it's that they abuse that authority that is given to the decision maker. You could play replace or cut and paste with the adjectives if it helps you. I mean, clearly unsound, clearly unreasonable, clearly unsupported by substantial evidence. Is that better or worse, or is it?
It sounds better, and based on, I spent a couple hours researching patently unreasonable, and most of what I found had to do with Canadian employment law, where
now you found me out. I'm a secret Canadian.
Well, but there were several cases that it was pretty much ruled a non-issue, that unreasonable and patently unreasonable had to be exactly the same thing. But in effect, what the Canadian courts ruled was that it did place a higher standard, which made it more difficult to contest what was unreasonable.
And I don't dispute that at all.
Yeah, I mean, there again, I have no problem with stuff being clearly unsound or clearly unreasonable. But grossly unsound, I don't know. I mean, to me, that is like applying unwillfully and unlawfully, doing an act. It's, I don't know the motivations behind all the supervisors. I would tend to think that they're on the up and up 99 and 9/10% of the time. But trying to prove that their decision was grossly unsound. I mean, there you go. We'd have to put in definitions what's grossly unsound compared with what's unsound or clearly unsound.
Let me point out, Mike, just briefly, and this might make board members feel a little better about it. Not that I'm trying to argue the city's aspect of this, but if that's your rule, I think there's some advantage in a well-established legal concept, because again, otherwise what you've been stuck with has been justified, and justified means justified. Malkovich. It would be, there's some utility in having something that I, as your counsel, can say, okay, this is what's before you. Here's what the case law says this term means and how to weigh it.
Yeah, and I mean, and I sort of agree, but I mean, it just seems you're arbitrarily raising the level of what unsound would be, or unreasonable would be, or unsupported by substantial evidence would be.
Well, I'm gonna push back with the idea of this being an arbitrary thing, because this is coming from this as a legal standard. Grossly unsound, gross negligence is how I commonly think of the term gross being used in law, but grossly unsound, patently unreasonable. These are well-established standards from administrative law, which is the area that we're in here. And I don't feel there's anything arbitrary about the standards.
Oh, well, and maybe arbitrary is the wrong word. It just seems that it's making it relatively more difficult to show that there was unreasonableness or unsoundness. You know.
Well, one way of saying that would be that we're making the show that there was abuse, that the discretion that the advisor had was abused, that they're using it wrongfully, and so I feel like those terms get that across.
Well, the thing about it is, and I'm not sure that abuse of discretion is even a proper term. You know, I'm not being intentionally trying to abuse discretion, but my judgment could still be unsound at the moment. You know, without purposely trying to abuse.
Well, I don't think that's necessary, Mike. In our Maddox and Henning can tell me if I'm wrong, or even Mr. Webb. But I don't know that you have to intend to abuse your discretion for it to be an abuse of discretion.
That's correct. Intent is not an element of this.
Yeah.
Okay, I mean, then why are we putting in all these extra adjectives to define unsound, unreasonable, and not supported by the evidence?
Because that's the dictionary definition of what that word means.
That's not what I'm reading, and I'm looking at the dictionary.
The law dictionary.
Hey, John Maddox, maybe you could give us a copy of that definition. I've just, my brief search of this, I haven't found that definition either.
Oh.
The definitions that I'm looking at, abuse of discretion, always are in the context of appellate court's decisions. So, for instance, I've got a law dictionary that from my law school days. It says abuse of discretion is a failure to exercise legal discretion. And then it goes on to talk about the rationale by an appellate court. But then it goes on for abuse. The definition of abuse is misuse, or to mistreat physically or mentally. And then there's a definition of discretion.
I would have to go back to the blacks that's in my office down at City Hall. That was what I would.
Let me just finish real quick. Discretion, it says use of one's own judgment in making a responsible decision. That's discretion. So to me, it seems like you could say misuse of one's own judgment in making a responsible decision. I don't know. I mean, if you've got a copy of that Black's Law, maybe that would be helpful for us to see.
I will try to dig that up.
Okay.
You know, my administrative law background, back before I was city, I did a lot of law cases and dealt with in the federal court and dealt with what we call Chevron deference, which is the standard that regulatory decision agencies use. And this is where a lot of my administrative law thinking comes from. When, let's say, the EPA creates a new environmental rule, the court looks at that and says, okay, and it's called Chevron deference because it comes from a case involving Chevron. But basically, the agency creating the rules is they're in the driver's seat. Unless it is really out of bounds, the court does not step in. And the reason for that is recognizing that these administrative agencies, their scientists and their public comments and their thinking over this for a period of years are in a better position to make the decision than the court is. So unless they're going really out of bounds, they're not going to overturn a rule. I'm trying to create something like that here with the city's agencies, with the city's departments. So unless they're really getting out of bounds, they're going to be able to function as they think best. And yes, I'm being completely upfront with all of you. I am trying to remove some of this board's discretion over those decisions and place more of it with the department. I think that's what the city needs, or that's for years. It's not me saying it. It's the city has said for years that is what it needs. And I do think that we would all benefit from having more certainty around the decisions that departments make with regard to their personnel. And that's the thinking behind this. So I'm glad to play with this definition a little bit, but I am going to strongly advocate for terms that get that across.
I think if I could add, John, we're all in agreement actually in what we're trying to get to. We want city supervisors and leaders to have discretion. We want that, and we want to support their decisions even when we disagree personally with their actions. But I think what we want to avoid is the unenviable position to have to back up what's clearly an unsound, unreasonable, and unsupported decision. And we have to, when we're being interviewed by the press, say, we agree that that decision was unsound, unreasonable, and unsupported. But unfortunately, your civil service board in order to rule against a supervisor, it has to be grossly unsound. It has to be patently unreasonable. It has to be wholly unsupported by substantial evidence. And you, Mr. Public, have to understand that your civil service board cannot judge these cases by simple unreasonableness or unsound judgment or lacking evidence. You know, I think it's just where that boundary occurs. I think we want to be in a place where we can look at the public and go, we're doing our job, you know, and not just be merely somebody that decides whether a supervisor is acting in some alien standard. None of us can really get our heads around, because it's even hard to imagine any case coming before the Civil Service Board where a supervisor had exceeded this kind of a boundary. You know, it's so far out there.
Well, I think if the board wants me to, I will work with Mr. Henning to try to get to a good place with this language, a place that y'all feel like you can support. And ultimately, it might just be that the city council is the ultimate decider. Because once y'all pass on this rule, it's up for the city council to amend and adopt them. So if they feel like the language that this board ultimately lands on is not strong enough or is too strong, then they can certainly change that around.
That's fair.
Okay. Does anybody else have any other thoughts, comments, observations, questions?
Madam Chair, I just want to find out from Mr. Maddox before he gets away how he became a secret Canadian, because having, at least speaking for myself, I've thought about being an actual Canadian at some point. So I just want to know.
Yeah, I want to know too, John. I mean, especially given the current,
Dual citizenship, right?
like I want to see how this
Well,
Yeah,
it,
Part, yeah.
it's sports passports, but mostly you just have to have a whole lot of maple syrup. Just still maple syrup.
Bacon.
And eventually, once your blood sugar is actually a certain ratio of maple syrup, this is a little known fact. They only tell you this in law school. You are actually a secret Canadian.
Does it count if I voted for Trudeau?
Well, I think we're going to have some issues with your ballot. And actually, I want to thank for giving me an hour where I wasn't just refreshing a news site every 5 minutes to see if we have a new president yet.
Well, is there any new business to come before the board today? Mr. Eskovich?
I just want to, it's not new business. I just, for procedure going forward for our next meeting, I just want to be sure that we do extend invitations to the PBA, FOP, and IAAF, the Firefighters Association. And if Mr. Tullis or Sergeant Tullis can't be present, that hopefully somebody representing the PBA can sit in on his behalf.
And I would ask, is it possible, well, two things, that in addition to the invitation, that they can get copies of the rough drafts or the notes ahead of time, as well as us, if there's any updates or changes, so we can have a couple of days or a week preferably to review it.
I will do my level best. Between now and then, there is a Thanksgiving holiday. And I mean, there's sometimes these things are getting worked out at the last minute just due to scheduling, certainly with some uncertainties been introduced by Mr. Tullis being ill. Do my level best. I will say I have no ability to compel anybody to be here, and there comes a point where these groups, if they want to come speak, they can come speak, and if they feel like they don't want to, then I don't know, then they won't.
Understood.
And you're exactly right, John. We can let them know, and if they come, they fine. And if they don't, then that's fine too. But at least they can't say that we didn't offer them a chance to have their thoughts heard if they so wish.
Absolutely.
If there's no new business, is there any public comment? Are there any members of the public who have any comments to make? Hearing none, are there any informal discussions, further discussions about future agenda items that we haven't already discussed? Ms. Long, is there anything else that you can think of that the board needs to address today?
No, ma'am.
Mr. Maddox, Mr. Henning, anything else that you all can think of?
No, ma'am.
No, Madam Chair.
Okay. Well, unless anyone else has any other last minute thoughts or observations, I will entertain a motion to adjourn.
Mike,
So move that we adjourn. Okay.
Is there a second?
Mike, I second.
It's been moved and seconded that we adjourn. Mr. Webb?
Aye.
Mr. Hahn?
Aye.
Mr. Eskovitz?
Aye.
Mr. Devereaux?
Aye.
And I vote aye. So we are adjourned, and by my calendar, our next meeting will be Thursday, December 3rd at 2:30.
Right.
Okay. Thank you, everyone. Have a
Bye,
great
everybody.
rest of the day.
You
Thank
too.
you all.
Bye-bye.